or not there were similar guidelines in place prior to the X case. Again, I think it's important for members to understand that each medical council, and each medical council has a term of 5 years approximately, each council publishes its own guidance. It is usually a refinement of the existing guidance. So the council would see each edition of the ethical guide as a further refining of guidance that the council offers. And of course, it's important for members to be aware that because medicine is constantly changing, we therefore need to ensure that the guidance that we offer, we provide rather, to doctors, it takes note of the fact that medicine is continuously evolving. And so the reason that the council publishes editions of guidance is to reflect the fact that medicine is constantly changing. So we of course had guidelines which actually pre-existed the X case, but the current guidelines that the Medical Council has produced, which you see in paragraph 21, reflect the current legal framework. Ms. Spillane, do you wish to make any further comment?
Just to respond on the point of the number of specialists available, I suppose just to say that again, the role of the Medical Council is to ensure that doctors who are on the specialist division of the register have the necessary knowledge and skills in order to be able to operate at that very high level. And we benchmark this to the best international standards. So it is the concern of the Council to ensure in the public interest that doctors who are on the specialist division of the register have the necessary knowledge, skills and competence to operate at that level. If a doctor has the qualifications necessary to enter onto the specialist division, well then the Medical Council will register that doctor. I suppose that there is also a role for the employer to ensure that there is an adequate number of doctors in whatever specialty, but there's also a role for the various different training bodies to ensure that their training programs are taking on into consideration future needs for specialists in various different areas. The Medical Council has a role in accreditation of postgraduate training, and it would be something that the Council would look to ensure that that the needs of the health service in the future are adequately addressed through the numbers of doctors being trained in various different specialties.
Thank you. Deputy Doctor, you indicated very briefly now.
Very briefly on the two questions that I've asked. The first one was, why do you not believe there should be specific provision for emergencies? If you could elaborate on that, coming back to the point that Deputy O'Quaid had made earlier in relation to numbers. And the second thing was, the question I asked was, has the guideline changed? Let's say the 6th edition, which would have been published subsequent to the X case, has there been movement, let's say, in relation to the guideline and how it's defined from the 6th edition to the 7th edition?
Thank you.
I'm not sure whether the 5th edition was before or after the X case, but since the X case, it would have been impossible for the Council to predict the X case in advance of it.
Thank you, Deputy. Very briefly, Ms. Spillane and Mr. Murphy, and then we'll go to the other members.
So with regard to the question on emergencies, again, in our submission, paragraph 6.5, we say in regard to the question of emergencies, the view of the Medical Council is that special procedures do not need to be developed for emergency situations. So I'm not sure we need to expand any further on that. The Council position is that we do not believe that it is necessary for special provisions or special procedures to be.
To help the members, would you just kind of outline as to why you think that would be the case?
Because we feel that the principles underlying a decision are similar, whether or not the situation is an emergency or whether it is non-emergency. We believe that the same procedures should apply in all situations. With regard to the second question, which relates to the question of the guidance, again, I suppose, as I mentioned earlier, it's important for members to understand that the ethical guide is a dynamic document. It is continually being refined. In fact, since the publication of the ethical guide in 2009, 7th edition, the Council has issued further guidance earlier last year rather, on the interaction between doctors and industry, which I know many members will have seen. So I think that as medicine constantly evolves, clearly the guidance that the Medical Council offers doctors clearly changes. So with regard to this specific point of abortion, as I mentioned earlier, all doctors work within the law of the land. Clearly, with the Supreme Court judgment, the law of the land changed. And so clearly the guidance that the Council offers to doctors and requires them to adhere to reflect the current legal position.
Thank you. Okay, we have 5 members who've indicated now in this particular segment that we've left, so I'm going to call on Deputies Dowds, Healy and Byrne, along with Deputy Fitzpatrick and Senator Crown. So Deputy Dowds.
Thank you, Chair, and thank you for coming in to address us. In your submission, Professor Murphy, you state that sections 58 and 59 of the 1861 Act should be repealed. Just for the record, could you just clarify what exactly those sections state? And my other 2 questions relate to the issue of situations where doctors have to deal with pregnant women where in order to save their life a termination of pregnancy would be necessary. To what extent are they in a legal quandary at the moment because of the lack of clarity of legislation? And in relation to situations where it's in the interest of the woman's health that a pregnancy is terminated, am I right in thinking that medical professionals can't take any action in that situation in terms of a termination? Thank you.
Thank you, Deputy. Deputy Seamus Healy.
We're here looking to thank the Medical Council for coming in. With respect to Cathaoirleach, I think we need to ask the invitees again in relation to emergencies and locations. With respect, I don't think they've adequately responded to the questions from the members in relation to that. On page 4 of their submission, 6.5 and 6.6, the Medical Council have put forward a particular point of view. They've responded in respect of emergency, which I think is not adequate, but they haven't responded at all in relation to the question of location. And they say there that the location of medical facilities is a matter for the Minister for Health to determine under criteria set out under licensing regulations. But I don't think that's in fact good enough. I think we need to know specifically from the Medical Council what is their view in relation to the locations. I don't think what we've seen there is adequate. And could I ask for the Council to expand and clarify on those 2 areas in particular, and also if there's time available to just clarify and expand on the whole question of conscientious objection. Thank you.
Thank you, Deputy. Deputy Catherine Byrne.
Chair, and first of all I want to thank Ms Luddy and Professor Murphy for coming in this morning to us. Thank you. Mine is just in relation to one that was about emergency, so it's been asked 2 or 3 times, so I won't go back over that. Just regarding paragraph 21, the guides relation to abortion. Just in 21.4, could you just expand on the 3rd line, and due to the extreme immaturity of the baby, could you just expand on that line for me? What does that exactly mean? And how can you explain that extreme immaturity to the fetus or to the baby? Thanks.
Okay, thank you. I'll also take Deputy Fitzpatrick and Senator Crown in this slot. Deputy Fitzpatrick.
Just Professor Murphy, the procedures to determining the entitlement and access to the termination of the pregnancy. These questions have been asked and asked and asked again. Like, treating doctors' opinions and decisions should be documented. Can you elaborate more on that there? Also, the diagnostics should be evidence-based within a defined time limited. Can you define more? These are questions that have been asked day after day after day. And then the last one then is the diagnostic should be notified by the treating doctor to the woman. These are things that people automatically think will happen. I think you explained it so far in your documentations, but I wonder, would you elaborate a bit more, please?
Thank you. Senator Crone.
Gramag Kirlick, and I'd also like to thank my colleagues from the Medical Council for coming in. I have a few quick questions. In the first case, Professor Murphy, I would like if you could give us a very concise, basically a yes-no answer on the question as to whether you think the current situation where our practices are guided by the Constitution as interpreted by the will of the people in referenda and by the courts, as opposed to through legislation, provides an adequate framework for doctors to practice. Is there a problem which needs to be fixed?
To the microphone.
Is there a problem? Well, I'll sit down then if you don't mind. Sorry. Microphones were obviously designed for shorter parliamentarians.
Long-winded, Deputy Senator.
No, indeed. Is the current situation adequately regulated, do you believe? Is there a clear and present need for legislation? Because this argument has been advanced that we don't actually need one. The second one is a little more contentious, and I'll understand if your answer is somewhat nuanced on this, Professor Murphy, but over the years, those of us in our profession who have looked at medical council elections have been aware of rumours that there have been serious attempts at entryism over the years by people who wish to advance a particular agenda in terms of medical ethics on the council. And the issues that have arisen with respect to emergencies and also to the number of doctors, I just wonder, was this a unanimous position that there would not be a specific determination? Was it a consensus position? Was the fact that there has not been a recommendation about emergencies and that there has not been a recommendation about the number of doctors reflecting the fact that the council felt it wasn't necessary, or that the council could not get agreement on this matter? Because certainly looking at it from the outside, one would suspect that the latter may be the case. And thirdly, one technical question for those of us who find ourselves in this situation. My understanding and the interpretation of the 1992 referendum allowing freedom of information was somewhat different to that which is being elucidated, which is being outlined today. If someone asks me the question, will my health be enhanced if I have this pregnancy terminated? And if I answer yes, am I in breach of medical council guidelines?
Okay, thank you. Mr. Murphy.
So quite a number of questions. So maybe I could deal with Deputy Dowd first. You've sought clarification on sections 58 and 59 of the 1861 Act. I don't happen to have it off pat, but I can read it to you. Section 58 says, every woman being with child who, with intent to procure her own miscarriage, shall unlawfully administer to herself any poison or other noxious thing, or shall unlawfully use any instrument or other means whatsoever with the like intent, and whosoever, with intent to procure the miscarriage of any woman, whether she be or not be with child, shall unlawfully administer to her or cause to be taken by her any poison or other noxious thing, or shall unlawfully use any instrument or other means whatsoever with the like intent, shall be guilty of felony, and being convicted thereof shall be liable to be kept in penal servitude for life. And section 59, whoever shall unlawfully supply or procure any poison or other noxious thing, or any instrument or thing whatsoever, knowing the same is intended to be unlawfully used or employed with intent to procure the miscarriage of any woman, whether she be or be not with child, shall be guilty of a misdemeanour. So I hope that answers your question with regard to section 58 and 58 and 59 rather. I think that the question regarding the health of the woman, I think that the council was asked to comment on the expert group report. The expert group report was clearly about options for the government in implementing the judgment of the European Court of Human Rights, which related to the life of the woman rather than the health. And so consequently, the council has not taken a view on the health of the woman. With regard to Deputy Healy, I regret Deputy Healy when his view that we haven't answered adequately with regard to emergencies and also locations. If I can restate the council's position, on this. In emergencies, paragraph 6.5, we believe that special procedures do not need to be developed for emergency situations. We believe that the principles that apply to the clinical decision making should apply irrespective of whether or not it is an emergency. Similarly, with regard to locations, paragraph 6.6, we believe that the location of medical facilities is not a matter for the Council. It is a matter for the Minister for Health to determine, using criteria set out under licensing legislation. Deputy Byrne, question was regarding paragraph 21.4 of the guide, which deals with the first. Just bear with me. Extreme. Thank you. Extreme immaturity. Obviously, the council has been clear that really, when it says that due to extreme immaturity of the baby, in other words, there is very little chance that the baby will survive. I mean, obviously, if a baby is delivered over 28 weeks, the likelihood of the child surviving is very high. But if the child is less than 20 weeks, then clearly that is inconsistent with survival. I suggest that this is an issue that should be teased out more with the obstetricians when they make their submissions to you later on this morning. With regard to Deputy Fitzpatrick and the question with regard to evidence-based, I think that you'll see in the paragraph 21.1, we believe that that last sentence of paragraph 21.1, the Medical Council says in its guidance, you should undertake a full assessment of any such risk in the light of the clinical research on this issue. This really reflects the fact, as I mentioned earlier, that medicine is continuously evolving and that doctors are encouraged to utilize the new research in order to inform their decision making. Council members of the Oireachtas will be aware, different forum, members of the Oireachtas will be aware that there is now a requirement for all doctors to maintain their professional competence, and they do this. It's a legal requirement, and they do this by ensuring that they remain up to date in their practice. The purpose of this is to ensure that the public is protected because their doctors are currently up to date and because they have informed themselves about new research in their particular area. I think then finally, Deputy Crown, I think that the issue that he has raised, I think, with regard to the clarity for doctors. Firstly, I would say that clearly this is a question that should be put also to the obstetricians and to the psychiatrists when they make their presentation to you later this morning. I think the Council's view is clearly that it is in the public interest that doctors have legal clarity when making clinical decisions. And insofar as legislation underpinned by regulations will provide that clarification to doctors, the Council supports its introduction. Again, it's important that members are aware that the guidelines that the Council issues it's not a legal code. They follow on from legislation. They reflect the current legal framework. I'm not sure if Ms. Behan wishes to add anything further.
I suppose just to take the opportunity to reiterate how the Council developed the guide. This is probably the most important document that the Council will produce in its lifetime. The guide was produced by the Ethics Working Group, and this working group was made up of Council members and non-Council members, and it was chaired by by a non-medical member of council. The ethics working group took an evidence-based approach to the development of the guide, and its development was underpinned by quite widespread consultation. The group would have consulted with patients, would have consulted broadly with members of the public, with patient safety representatives, with medical schools, postgraduate training bodies, doctors and doctor representative bodies. Really everybody was involved in the consultation process, and this is something that the council, this particular council, has prided itself on, the fact that it consults very, very widely on very key pieces of guidance and documentation for doctors. The ethics working group has as its reference the law of this jurisdiction, but its work is very much in line with the approach that would be taken by other medical regulatory bodies internationally. Thank you.
Thank you. Senator Crone, you indicated.
I'm sorry, with great respect, I just feel that my questions have not been addressed. The specific question I asked Kieran Murphy, Professor Kieran Murphy, is, do you believe that the situation at present provides clarity? Does the situation at present provide clarity? Does it need to be addressed? And number two, I'd just like to state that you have stated yourself that the council exists to protect the public, and it does. And I think in the interest of public protection, you need to answer the second question, which I think you've skipped over. Did the council deliver any watered-down set of recommendations specifically on the issue of emergencies and on the issue of the number of doctors because consensus could not be reached within the council on these issues? Or did the council believe that such recommendations were not necessary and that the public interest would not be served by the medical council expressing an opinion on them?
Deputy Kelleher.
Just in regard to conscientious objection in the event of legislation being passed and terminations being provided and clarity being brought to bear, should that be made public? In other words, I mean, if a person has a conscientious objection to carrying out a termination, when would the obligation be on the clinician to inform peers or the administration of that particular location? When would they be obligated to inform? Would it be at the start of their contractual basis, or in the event of an actual individual procedure coming to being? Should there be an obligation, and for that also to be published, that these people have a conscientious objection to a particular procedure in relation to termination of pregnancy?
Okay, thank you. Mr. Murphy.
So I regret that Deputy Crown feels that my previous answer was less than expansive. I think that clearly the government has decided to introduce legislation underpinned by regulations. And insofar as the introduction of legislation and regulations it provides clarity for doctors to ensure that they can best protect patients, the council clearly welcomes that approach. I think with regard to his second question, with regard to consensus or otherwise, clearly the council speaks with a collective voice. The council is made up of 25 members. There is a lay majority of members of council. Members may not be aware of this, but in fact our council is the only regulatory authority in the world that has a lay majority. So there are, of the 25 members of council, there are 12 medical members and there are 13 lay members. So we have a lay majority. It's true that like every grouping within society, each group attracts this variety of opinion that's consistent with our society. So like in this chamber, the Medical Council is comprised of many different views. Nevertheless, the council has agreed on a consensus view, which is the submission that we have made before you today. With regard to Deputy Kelleher's question about conscientious objection, again, if I can refer you to our current guidance on the issue, paragraph 6.9, our current guidance, and I think it's worth again saying, our current guidance 10.1, as a doctor, you must not allow your personal moral standards to influence your treatment of patients. Paragraph 10.2, if you have a conscientious objection to a course of action, you should explain this to the patient and make the names of other doctors available to them. And 10.3, conscientious objection does not absolve you from responsibility to a patient in emergency situations. So I think we heard earlier this morning from Ms. Luddy with regard to the fact that she has clearly acknowledged that a lot of work needs to be done in policy really before work is done on refining regulations. The Council is very keen to engage actively with the Department to ensure that these issues are teased out and are refined in the regulations that are produced.
Thank you. Deputy Mitchell O'Connell, Deputy Quillan. I'm conscious we've got...
Thank you. Can I refer you back, please, to page 3 and it's 6.2, and you say, in regard to the question of the test to be applied, the view of the Medical Council is, and section B, the diagnosis should be evidence-based and made expeditiously or within a defined defined time limit. Can I ask you, please, what evidence-based are you talking about in that paragraph, please? Could you elaborate? And it kind of refers back to Deputy Regina Doherty here in front of me. She asked, in a different way, she asked about what kind of risk assessment or what happens when you're going to make a decision. Thank you.
Thank you. Deputy Quillan.
Just again, accepting that all cases that do and can present are unique, in the formal review process recommendations that you've placed out in section 6.7 of your submission here this morning, you speak A, B, C, D and E going through independent, accessible, transparent, competent and timely. So on the issue of timely, I'd like to ask you, Dr. Murphy, how long do you believe is reasonable for the establishment of a formal review process and the issuance of its decision? And given that you draw no distinction between a situation between emergency and all of the other situations, nevertheless, how do you understand emergency? Is this understood to be an immediate situation? Because there is a distinction drawn between emergency and other situations in the section 6.9.2 when you talk about conscientious objection. You do draw a distinction at that particular point in time. Can you elaborate and give us an understanding of timeframes in relation to all of these?
Mr. Murphy, thank you.
So to deal firstly with Deputy O'Connell and the question that she has raised with regard to what is evidence-based. So again, I think it's important for members of the committee to understand that increasingly the practice of medicine is evidence-based. So what does that mean? It means that to make a decision, a doctor must weigh up the available evidence. So in other words, he or she needs to ensure that the treatment option that he or she is providing for his patient or her patient is based on the best available evidence. So consistent with that council approach in its guidance to doctors, all decisions should be made with using an appropriate evidence base. So in other words, what that means is being familiar with the literature in this area to ensure that in fact doctors are guided to act in the best interest of their patients. Because clearly the role of the council is to ensure that doctors act in the best interest of their patients. And I think it might be helpful, perhaps we haven't referenced this yet, but I think it would be helpful if members could look at the introduction to the ethical guide. And in the introduction we say, in the first paragraph, the patient-doctor relationship is a privileged one that depends on the patient's trust in the doctor's professionalism. The role of the medical council is to safeguard the public by ensuring that the quality of the doctor's competence, behaviours and relationships that underlie this professionalism is maintained in the patient-doctor relationship. Then this is of sort of particular relevance to the current discussion. Second paragraph, this is page 7 of the guide. Doctors must always be guided by their primary responsibility to act in the best interests of their patients without being influenced by any personal consideration. They should act independently in the service of their patients and have a responsibility to advocate with the relevant authorities for appropriate healthcare resources and facilities. It's very important that doctors understand that they need to, at all times, act with the patients as their primary interest. And every action that doctors take has to be guided by that principle. And so, as part of that process, the Council reminds doctors that any decisions that doctors take need to be guided by what the evidence is that supports their decision. With regard to Deputy O'Quailon, he has made reference to the formal review process. Again, clearly, as Ms. Luddy indicated earlier this morning, a lot more work needs to be done in trying to tease out the individual detail that will be contained within the regulations. And clearly the process that we are undertaking today and for the next 2 days will inform the debate. Clearly, it is important that you, as members of the Oireachtas, seek information from the obstetricians and from the psychiatrists who are faced in clinical practice with these scenarios. So I think that the purpose of the Council document is to set out the principles which need to be safeguarded so that the Council can be assured that the protection of the public is maintained. And I think that this clearly will evolve with the development of regulations. And as I mentioned earlier, we are very keen to work with the department and other stakeholders to ensure that those principles that the Council has set its position on are maintained in the development of these regulations.
Thank you. Very briefly, Senator Burke. Very briefly now.
Just very briefly, just in relation to the options set out in the expert report, and you referred to it in paragraph 6.4 of your report, and I know you don't want to come down on one side or other on the 3 options. Therefore, could I ask the question, do you believe that all 3 options are workable?
Mr. Murphy.
So, as you mentioned, Senator Burke, option 6.4 of the expert group report, the Council has set its position, which is legislation and/or regulation should set out criteria for the number and role of doctors to be involved. The Council will actively engage with the Department of Health in the development of regulations in collaboration with other stakeholders. And 2, the legislation and/or regulations should include a requirement that doctors involved have sufficient knowledge and skills to facilitate appropriate clinical decision-making. The Council's primary concern, as I mentioned earlier, relates to protecting the public. How the Council feels it can best do that is by ensuring that the education and training of a doctor is of an appropriate standard that is benchmarked favourably internationally. How we do this, as Ms. Spillane said earlier, was by ensuring that that entry onto the specialist division of our register is that hallmark of quality. That, for the Council, is the standard by which it can be reassured that members of the public are protected.
Okay, thank you. Okay, as members have utilised their 60 minutes, I now go to members of the committee who are not members of the committee, members of Oireachtas, and Deputy Terence Flanagan, you've indicated his questions, please now.
Thanks, Kerry. Just to ask in relation to the Medical Council guidelines in paragraph 21.1, which relates to abortion being illegal in Ireland, the exception obviously being where there's a clear and a substantial risk to the life of the mother arising from a threat of suicide. And obviously these guidelines are directed towards doctors, and it says that you should undertake a full assessment of any such risk in light of the clinical research on this issue. So just to ask, what is the current clinical research supporting the idea that abortion is an appropriate treatment for suicide? And regarding the guidelines then as well, further on, paragraph 21.4 refers to rare complications which may arise where there's no hope of the baby surviving, that it may be necessary to intervene to terminate the pregnancy to protect the life of the mother while making every effort to preserve the life of the baby. Just to ask from the Medical Council point of view, like what's unclear relation to that, and to ask as well as to what level of correspondence have you received from doctors relating to the lack of clarity regarding the guidelines, and to ask as well, are you aware of any deaths due to the lack of clarity regarding the guidelines? And just in conclusion, if you wish to see the Offences Against the Persons Act 1861 repealed, do you think that there should be any duty of care whatsoever towards the unborn child in legislation? And if so, how do you consider that should be achieved?
Thank you. Deputy Billy Timmins. Deputy, 2 minutes.
Thank you, Chairman. I have two brief questions for the Medical Council. However, before I put them, I would like to put on the record the fact that I find it extraordinary that the committee would actually excuse the Department of Health from undergoing questions during this period.
No, we explained earlier, Deputy, in your absence, that the Department are not running away. They will come back again at a future date, but that the legislation has not been drafted yet, and at our meeting last night it was agreed that we will wait until the publication of the heads of bill to engage further, and that was made quite clear.
No,
that was agreed by the committee unanimously.
Chairman, I don't want to go into conflict with you. I was actually here. I was here when you actually made that point. I wasn't absent.
Okay, sorry.
But, and the reason I say it, I do think it is important that I point out the purpose of this committee is not alone to inform ourselves, but also to inform the wider public on the issue. And I am of the view that there's a broad view amongst the public that the expert report, when dealing with this issue, was dealing with the issue in its broad concept, however, in line with the actual commitment in the programme for government. But that actually wasn't the case, because the terms of reference very strictly limited, or the interpretation rather of the terms of reference limited this to advise the government on how to give effect to the existing constitutional provisions. So when the government drew up the terms of reference in November 2011, whether unwittingly or otherwise, the decision was made to legislate for the X case at that time. I would like to have got clarification on that from the Department of Health, as I would also like to have got clarification on where stands the report into the tragic death of Savita Halapanavar, because, the majority of representations I received on this issue dealt with that case, and we don't know where it stands at the moment.
On that particular point, as you know, Deputy, that's not part of our remit, the last part of your comment. Okay.
I'm quite aware it's not part of your remit, regrettably so. Okay. And thirdly, actually, also the issue of capacity that's raised by the Medical Council. I would like to know, what's the time waiting list for a pregnant person to see a perinatal psychiatrist in this country at the moment? I think it's important to clarify that. But to come back to my two questions, and thanks for bearing with me, Chairman, to the Medical Council. Have the Medical Council received any complaints from medical practitioners with respect to the guidelines as they currently exist? One. And secondly, was there a request from the Medical Council to any government since 1992 to have the guidelines legislated for?
Okay, thank you, Deputy. And Senator Jim Walsh.
Yeah, just following on that, and thank you, Chairman.
2 minutes, Senator.
2 minutes, yeah. Following on that, can I just say, if you could identify any deficiencies that you recognise are in the particular current guidelines that need to be addressed. I'd like to ask in relation to the guidelines as well. The Medical Council recognises the distinction between abortion, which you've mentioned, termination of pregnancy arising from the course of therapeutic intervention, in which every effort is made to preserve the life of the baby. How would you define that distinction? My second question would be, you mentioned that diagnosis should be evidence-based, and indeed the expert group report recognises the difficulties that there is in predicting suicide in particular. Could I ask you, what is the evidence base for suicide as a grounds for termination in your view? And thirdly, can I ask, do you believe that there are two patients in a pregnancy, and that the two-patient approach which we've had traditionally up to now has served us well, has a good record, and that we have a duty of care to both the mother and the child?
Thank you, Senator. Mr. Murphy.
So if I can deal with the first question first, then, which was really relation to the paragraph 21.1, and I think the question really related to paragraph, as I say, 21.1, that final sentence: you should undertake a full assessment of any such risk in the light of the clinical research on this issue. So I think, as I mentioned earlier, medicine is continuously evolving, and that it is a principle of the Council that doctors need to ensure that they remain up to date. So within their particular field, it is important that doctors' knowledge and skills remain current. This, of course, was one of the prime reasons why the introduction of mandatory professional competence was introduced. because now all doctors, there's a requirement for all doctors to ensure that their practice, their knowledge and skills remain current and remain up to date. This, of course, is to ensure that the protection of the public is maintained. So the question about current research, clearly this kind of relates to doctors need to be informed of all research in their area to ensure that they will be enabled to make the correct and appropriate decision to ensure that they serve the interests of their patient. And as I mentioned, and as I read out earlier, I won't read it out again, that doctors should be guided by their primary responsibility to act in the best interests of their patient. Moving on to 21.4, and I regret that the deputy feels that paragraph 21.4 is unclear. I think as Ms. Behan outlined earlier, and I think as we outlined in our submission, the guide that the Medical Council produced in 2009 was developed following extensive consultation with doctors, with the general public, with medical schools, with postgraduate medical training bodies, with government departments, with employers and a range of other stakeholders. In order to ensure the guide is as relevant as possible, the Council established an ethics working group to oversee the development of the guide. This multi-stakeholder working group, which included Council members and non-Council members, including a number of medical and non-medical experts, was established to ensure that the guidance was both evidence-based and developed in line with best practice. So I think also, which I haven't said before, which is that the Council was very exercised to ensure that members of the public could also have access to the guide. So what this council did was that we actually obtained a plain English mark from the National Adult Literacy Agency, and on the inside cover you will see that we have that mark. The purpose of that mark was reflected the desire of the council that patients and members of the public should be able to understand the standards that the council expects of doctors, that members of the public need to understand what standards that doctors are judged by, and what standards that doctors are obliged to adhere to. So I think that we have tried extremely hard in order to ensure that we have had maximum levels of consultation in the development of our guidance. The language of the guide that we have used, we have worked very hard to ensure that it is as accessible as possible to all members of society, both doctors but also members of the public. I think
might address them as well.
Which question was that with regard to?
In terms of the
what correspondence have you received from doctors that the guidelines are not legible, that they don't understand them? They can't.
So, as part of the consultation process in the development of guidelines, of the Medical Council's guidance, we clearly consulted widely with a range of different stakeholders, members of the public, members of the profession, the medical schools, the postgraduate training bodies, the advocacy groups. And clearly the Council decided, based on consultation, the appropriate guidance that it decided to publish to guide doctors. With regard to the issues of capacity, and I believe that the question relates to the capacity of the healthcare system in order to manage, rather than the sort of capacity of the individual patient to give consent, which is clearly dealt with separately in the guide. Clearly, it's a matter for the employer to determine the capacity within the healthcare system. I think clearly this is a question that I think should be posed to the obstetricians and to the psychiatrists when they make their submission later this morning to answer that question. I think, again, the third set of questions again made reference to what was termed deficiencies in the current guidelines. I have tried to outline, and I won't say again what I've just said now, earlier, that the Council, briefly, the Council has gone to extraordinary lengths to consult about the guidance that it gives to doctors, and following an extensive period of consultation. I think that the issue of evidence-based, again, I think reflects earlier questions, and it also reflects our earlier replies, which are that like the guide, medicine is continuously evolving and changing, and clearly the guidance that the Medical Council gives to doctors needs to reflect the evolution of medicine. Ms. Behan, do you wish to add anything further?
Sorry, I'll bring it at the end. I'll bring it back in at the end.
Thank you.
Ms. Behan, we've 9 minutes in this slot left, so, and there's 2 people who have indicated as well.
So just as regards the question posed by just as regards the question posed by Deputy Flanagan regarding the number of deaths from a lack of clarity on the legislation, I suppose just to reiterate that the Council can only take action on complaints that we have received. Those complaints can be made from patients, members of the public, and also colleagues of doctors and other healthcare providers. Last year we would have received approximately 420 complaints. As I outlined earlier, the categorisation that we have for our complaints, and all of this is available in our annual report in quite a bit of detail, and also in statistical reports that we produce, wouldn't have isolated out abortion as a category, but from our recollection we haven't received any complaint in that area of the guide. If a complaint is to be received from a member of the public or from a colleague of a doctor, and there's provision in the guide that says that if a doctor feels that another colleague has acted outside of the provisions of the guide, then a complaint could be made to the Medical Council. I mean, hypothetically, if a complaint were made, of course, our Preliminary Proceedings Committee, which is made up of Medical Council members and non-Medical Council members, it has doctors on this committee, but it also has lay members on the committee. They have powers to investigate complaints very comprehensively, and if they form an opinion that there is a case, then a hearing could take place on the basis of that. The vast majority of the Council's fitness to practice inquiries are now held in public, and that has been very informative for members of the profession in understanding how breaches of the guide can potentially lead to a complaint being made. It has also had an effect of informing the public about the expectations they can have over the standard of care that doctors should provide to them.
Thank you. So very briefly, because it's
very briefly, I agree with the medical guidelines being very clear, but none of my 3 questions were answered. None of them. First one, very clearly, the distinction, as you see it, between abortion, between abortion and termination of pregnancy in therapeutic intervention. Very clear. Next one is, what is the evidence base for suicide as a grounds for termination in your view today? We're talking about today. We're not talking about evolving medicine in 20 years' time. We're talking about today. And finally, is there merit in preserving our 2-patient system? That's a yes or no answer, with respect.
Senator Laross Murraku and Senator Paul Bradford. Constant time in this slide ends at 22 minutes past 11.
And I too would like to welcome the representatives of the Irish Medical Council and to thank them for their submission here today. As clarity is central to all our deliberations, as I see it, I would like to revisit that for a moment. Just to ask Professor Murphy, I understand that you're on record as saying that the guidelines were awarded a stamp of approval for plain English, and this was by the National Adult Literacy Agency. Now, in view of that, when did the change come, or do you still believe that the guidelines are plain English in that context? Because I think it's important that we establish at what stage we changed our views on the guidelines. Did that come from the Council itself? You did mention consultation, but you didn't exactly reply to the question as to how much correspondence you had received from practitioners on the lack of clarity on the guidelines. You must have some detail of that as distinct from the broader consultation to which you have referred. I also noticed from Ms. Behan, I don't think we got a specific answer on what knowledge you have of how many deaths occurred due to lack of clarity. I would like just to tease that out a little more with you, just those two questions, because I do believe we should clarify this issue for ourselves.
And finally, Senator Bradford.
Thanks, Chairperson. My question is a variation on the previous question. And, as we are asking the Medical Council to assist us in resolving the problem, I think we need to recognise what is the scale of the problem. So, Professor Murphy, could you indicate, and I think it should be possible to do so, what levels of complaints have been made to the Medical Council that are rising from our current constitutional position and perhaps medical practice that in some way maternal health, in other words the health and life of Irish mothers, is at risk? How many of those such complaints have been brought to your attention?
Deputy Flanagan, very, very briefly.
Very lucky. I had a number of questions that seem to be answered correctly. Just a crucial question, really. What clinical research supports the idea that abortion is an appropriate treatment for suicide?
Thank you. And Deputy Mahony, you indicated, I know you're a member of the committee, but you indicated.
Chair, I didn't intend to ask any questions. Just slightly concerned that the direction that this hearing is going in, because from my knowledge of the European judgment, which is why we're here at these hearings and why we've invited people like the Medical Council here, there is no reference to what the Medical Council did or didn't do. There's a lot of reference to what people like you and I, as politicians, didn't do, not for 20 years, but for 30 years. And I have to say, I have a dislike of the way that this is tilting towards people who, I think this gentleman, in fairness to him, has made it clear about 11 times that what he's talking about is based on regulation. He's not a legislator, and you're perfectly right. So the shortcomings are our shortcomings, asking people their opinion about A, B, C and D. With respect to the Medical Council, at the end of the day, it is this Parliament who will decide on what the European judgment was and will decide on the outcome of the expert report. Regrettably, that we have to be here 30 years after this.
Mr. Murphy, very briefly, because our time is allocated as elapsed.
Thank you. So perhaps I could deal with Deputy O'Murrucu's question first, which really relates to this plain English development. So let me just give you the background to the stages, because that was your particular question. So after a period of extensive consultation with all stakeholders, the council produced its draft guidance. This draft guidance was then sent to NALA for them to examine the language of the guide, not clearly to change the substance of the guide, but to ensure that the principles underlying the guidance were sufficiently clear to a lay audience. So we had quite a considerable interaction with NALA, in which there was a further refining of the language of the guide. When the council agreed with the final version of the guide, it was then published. So the guide that you have before you relates to the final version of the guide that was agreed by the council in 2009. Now, as I mentioned earlier, the guide is a dynamic document because medicine changes, and clearly the guide has to reflect that. Last year, we published supplementary guidance for the profession on the relationship between doctors and industry. And the next council will clearly also publish a revision of the current ethical guide. With regard to Deputy Bradley, excuse me,
Senator Bradford again.
Bradford, so excuse me. With regard to Deputy Bradford, I think the question was whether or not there have been complaints about the current guidelines with regard to abortion. I think, as we mentioned earlier, I think that the council receives complaints if a doctor is deemed to be in breach of the guide. So clearly, as I think we mentioned at the start of the session, to the best of my knowledge, we have not received any complaints that a doctor is in breach of the current Medical Council guidelines on abortion. I think with regard to the first question on the evidence base for suicide, I think that the principles underlying the Council's guidance are that doctors, the principles underlying the Council's guidance are that doctors need to be the most informed when they are making clinical decisions. So they need, their decisions need to be guided by the available evidence. And so consequently, it is imperative from the Council's point of view, in order for it to fulfil its mandate to protect the public, that all doctors are guided by the best available evidence internationally to take appropriate clinical decisions that will ensure that patients are protected. And I think that also, I think covered that last point, which is the research and the evidence for any intervention. As I said, Council's view is very strongly that any clinical decision that is taken needs to be guided by the best available evidence, and it is up to the doctor. And again, I think it is probably worthwhile also, I think, reiterating that in fact doctors have guidance from lots of different sources. The Medical Council guidelines are one set of guidance that doctors have. So, for example, within psychiatry and within the new clinical care programs, there are specific guidelines being developed by the clinical care programs within the HSE to manage a range of different clinical scenarios, for example, self-harming. So I think that the doctor is expected to adhere to all the guidance. So guidance from the Medical Council, but also practice guidelines that are published by the employer, by the HSE, through the clinical care programs, but also guidelines that each training college, each Royal College, also produces for each specialty. So I think it's important for members to understand that the Medical Council guidelines are not the only point of reference that doctors work through. That in fact doctors are guided by a range of different practice guidelines and protocols, of which Medical Council guidelines are just one component.
Okay, thank you. Okay, as it's now 26 minutes past 11 and we've reached the allocated time for non-members of the committee, I might ask Mr. Murphy to make a final summation if you wish. If you wish.
So the Medical Council is very grateful for the opportunity to make a submission to the Oireachtas Committee. This is a very, I think, challenging issue for everybody. I think that the Council will work very actively with the Department of Health and other stakeholders to ensure that the public is protected with regard to any action that is taken. Thank you very much.
Thank you very much, Mr. Murphy. And may I thank you and Ms. Caroline Spillane for coming in this morning to us, and to thank Ms. Luddy from the Department of Health. Our committee stands suspended until 12:15. Thank you.